This video will cover real, personal, and intellectual property law. When we look at the definition of real property, it is the land and everything permanently attached to it. I did claims in insurance years ago, and what they used to tell us to do was to take a property, flip it upside down, and shake it. And anything that sticks to the ground is probably real property, and anything that fell out is going to be considered personal property. So that's just a visual way to interpret what real property is. But real property is the land and everything permanently affixed to it. So that would be trees, etc. Land ownership extends to surface rights, airspace, water rights, and mineral rights, also known as subsurface rights. Surface rights include things like trees, buildings, fences. Subsurface, or kind of the things below the ground, subsurface rights include things like oil, coal, and mineral rights. So when we talk about airspace rights, above 500 feet of the highest part of the property, subject to aviation and other zoning ordinances, is generally the rule that we use to determine what your airspace rights are. There's a case called U.S. versus Cosby that really set the precedent for defining rights beyond, the actual land.
Law Center. Here's Dean Leonard Baines.
Do homeowners own the airspace above their land? That question was addressed in a 1946 U.S. Supreme Court case, U.S. versus Cosby, when a chicken farmer took the federal government to court and won. Thomas Lee Cosby owned a farm near an airport used regularly by the U.S. military. He argued the noise frightened the animals so much so that over 100 chickens died. Cosby argued the U.S. violated the Takings Clause of the Fifth Amendment by flying planes in the airspace that he owned above his farm. The Fifth Amendment says private property cannot be taken for public use without just compensation. Cosby won, setting forth that a landowner has a property interest over the airspace above his land. I'm Dean Leonard Baines.
There are different types of interests that a person may have in real property. Owner in fee simple absolute represents the right to possess real property for life and to will the property to their heirs upon death. Fee simple absolute is the most complete interest in real property. And a conditional estate is an interest comparable to a fee simple absolute, except that the interest will terminate upon the occurrence or non-occurrence of a specific condition. A life estate is granted for the lifetime of an individual. The right to possess property terminates upon the life estate holder's death, and the property will then pass to another designated party by the original grantor. A future interest in real property is a person's right to property ownership and possession in the future. A leaseholder estate represents the right to possess but not own property for a stipulated period of time. Many of us have seen leaseholding estates in that we have leases in our housing property. Easements, profits, and licenses are examples of non-possessory estates. An easement is the irrevocable right to use part of another's land for a specific purpose without taking anything from the land. An example of an easement would be like a utility easement. And a profit is a right to enter another's land and to take part of the land or take away a product of it. An example of a product would be the right to harvest timber from another person's land. A license is the temporary revocable right to use another person's property. An example of a license would be a theater ticket. Voluntary legal transfer of real property requires the execution of a deed, delivery of the deed to the grantee, with the intent to transfer ownership to the real property of the grantee. The grantee's expression of the intent to possess and own the property, in other words, the grantee's acceptance, and filing the deed with the appropriate county office in order to protect the interests of the grantee, is a process known as recording. Adverse possession and condemnation are two types of involuntary transfers of real property. Adverse possession occurs when a person openly treats real property as his or her own or as their own without protest or permission from the real owner for a statutorily established period of time. So in most states, there are rules around adverse possession. Through condemnation, the government acquires ownership of private property for public use after just compensation, and that's constitutional terms. that's paid to the owner even if the property owner protests the condemnation. So adverse possession may occur in a situation where somebody's like mowing a piece of property and they do it for a certain number of years and they start taking care of it. They automatically become vested in that property. An example of condemnation would be if the city decides they want to build a sidewalk and they want to take part of your property in order to build that city sidewalk. They would be able to do so after providing just compensation because it is for public use. These are oversimplifications of these two concepts. They're highly controversial, and there's a lot of case law around them. So now let's talk a little bit about personal property. Personal property is defined as all the property that is not land or not permanently affixed to land. So that would be things like your laptop or your sofa. There are two types of personal property, tangible and intangible. Tangible properties identified by the senses. So things like furniture, automobiles, whereas intangible property are things that are not identified by our, five senses. The bank accounts, stocks, that type of thing. There are two types of voluntary transfer of property. You can either purchase personal property or you can gift it. When a transfer of property is by purchase, the buyer gives some sort of consideration, hint, hint, back to contract law, of value to the seller in exchange for title to the property. When the transfer of property is by gift, the donee gives no consideration to the donor in exchange for title to the property. There are three elements necessary for a valid gift. First, there must be a delivery of the gift. Second, delivery must be made with the donative intent. And third, there must be acceptance, a willingness of the donee to take the gift from the donor. Involuntary transfer of ownership occurs when property has been abandoned, lost, or mislaid. Property the original owner has discarded is abandoned property. Anyone finding such property becomes its owner by possessing it. Kind of where that adage of possession is 9/10 of the law kind of comes from. Lost property is property the true owner has unknowingly or accidentally dropped or left somewhere. In most states, the finder of the lost property has title to the lost good against all except the true owner. And then mislaid property differs from lost property in that the owner has intentionally placed the property somewhere but has forgotten its location. The person who owns the realty on which the mislaid property was placed has the right to hold the mislaid property, since it's likely the true owner will return to that realty looking for the mislaid property. Now, I want to touch briefly on some concepts of intellectual property, but then I'm going to turn it over to the other video that I posted related to intellectual property. So intellectual property is defined as property that comes from creativity. There's different types of intellectual property: trademarks, trade dress, copyrights, patents, and trade secrets. And a trademark is a distinctive mark, word, design, picture, arrangement used by a seller in conjunction with a product, intending to cause the consumer to identify the product with its producer. So certain labels that you would see would be things that would be identified as trademark. A trademark must be registered with the U.S. Patent and Trademark Office. Further, the mark has to be renewed between the 5th and 6th years of registration. And then after the initial renewal, then it has to be renewed every 10 years after that. So remedies for a mark infringement include money damages if somebody's profited from that, and judicial issuance of an injunction, meaning telling people to stop using it. I want to introduce you to a band called The Slant, and I want you to listen to Michael Olivis talk about this case involving The Slant.
Here's Dean Leonard Baines.
Trademarks are distinctive and legally protected words, logos, and objects. Michael Olivis is an entertainment law expert. Michael, how are trademarks relevant to the entertainment industry?
Many entertainers pitch products. Run DMC's Daryl McDaniels has sued many large retailers for selling without permission the group's merchandise, such as their famous fedora hat. Beyonce and Jay-Z have applied to trademark their names and even the names of their kids.
What has been the Supreme Court's most important case on trademarks by musicians?
It was a courageous claim to use the Slants, a derogatory name for Asians, by an Asian American band. They trademarked the offensive name to reconstitute it as a form of affirmative pride. Federal law has a provision prohibiting disparaging trademarks, but the Supreme Court held for the Slants.
That was Michael Olivis, and I'm Dean Leonard Baines.
The term trade dress refers to overall appearance and image of a product. Trade dress is entitled to the same protection as a trademark. The main focus of a trade dress infringement case is usually whether there is likely to be consumer confusion in comparison of the two products. So something like a Louis Vuitton or Nike Air, that also had some issues with trade dress. A copyright protects the expression of a creative idea. So some examples of copyrighted material include things like books, musical compositions, plays, motion pictures, sound recordings, lectures, works of art, and computer programs. Three criteria are required for a copyright to be in place. First, it must be fixed. In other words, it must be set out in a tangible medium of expression. Second, the work must be original. Third, it must be creative. Remedies for copyright infringement include the recovery of money damages and judicial issue of an injunction. Again, this is where we're asking people to stop doing something. The fair use doctrine comes in handy for people like me in that the doctrine provides that a portion of a copyrighted work can be reproduced for the purposes of criticism, comment, news reporting, or teaching, like multiple copies of something being used in a classroom, scholarships, and research. Factors used to determine the applicability of fair use include things like the purpose and the character of the use, whether it's used for commercial nature. If you notice on the bottom of all of these presentations, there's something that says McGraw-Hill, all rights reserved. This is because the format of this PowerPoint presentation comes from McGraw-Hill, so it's copyrighted material. But I get to use it in certain ways, in that I'm not making additional money off of it. It's definitely something being used for educational purposes. So any charts or something that you see in these presentations, some of them are things that I've made, that some of this stuff is subject to copyright under McGraw-Hill. So when we look at fair use and we look at the purpose and the character of the use, whether or not it's used for this commercial or nonprofit educational purposes, the nature of the copyrighted work, the amount and substantiality of the proportion used in relation to the copyrighted work as a whole, and then the effect on the potential market or value for the copyrighted work. Another example would be like showing a video. A patent protects a product, process, invention, machine, or plant that's novel, useful, and non-obvious. So patents last for 20 years. Remedies for patent infringement include the recovery of money damages and injunctions. So if you're seeing a theme here, there's usually a length of protection, of something that it protects, and then the remedies that are going to be applied are generally money damages and injunctions. Trade secrets is an alternative to patent protection, and that represents a process, product, method of operation, a compilation of information that gives a business person an advantage over their competitors. Remedies for trade secret infringement include money damages and injunction. The right to a trade secret allows the holder to sue for violation if the owner can prove that the trade secret existed and that the defendant acquired the trade secret through unlawful means, and that the defendant used the trade secret without the owner's permission. So we see a lot of trade secrets among restaurants. So, KFC with their different spices and herbs that they use in the original recipe, that's a trade secret. Actually, my daughter works for Chick-fil-A, and there's a lot of Chick-fil-A TikToks and different things out there showing kids working at these Chick-fil-A's and showing how things are made. And some of that stuff's trade secrets, so it's all things that somebody can be terminated for. Again, our remedies are this money damages and injunctions, and to hold people responsible for what they have done. The owner can do that if they can show that there was a trade secret that existed. The defendant acquired this trade secret through unlawful means, and the defendant used the trade secret without the plaintiff's permission. And that'll conclude it for my end of property law.